Welcome to Lawyer on the Line.
Welcome back to the Lawyer on the Line podcast. I'm your host, Roger Riedmiller.
And I'm Mark Scott.
And today we are here to talk about what damages are recoverable in your personal injury, automobile accident, truck accident case. We're with Riedmiller, Anderson, and Scott. I've been practicing law in Kansas for 39 years, and we have run into all kinds of damages. So let's start talking about pain and suffering. Kansas has this concept of pain and suffering that can be recovered in personal injury cases. It is dependent somewhat on the nature and quality and quantity of your medical bills. At least that's the way I look at it. But there is no formula for quantifying pain and suffering, and it is totally in the province of the jury. What do you see, Mark, as the primary factors in determining how much pain and suffering a person can recover in damages in these types of cases?
So what we're seeing are, first off, those are what we call non-economic damages. So we have your classic, you have heard the terms before, pain and suffering, but there's also what is called emotional distress, mental anguish, or a couple of the different damages.
Okay, but what is your opinion as to what the major factors are in valuing? Because I know people are always asking me, is my case worth, a lot of money, or is it a moderate amount, or can you give me any idea how much my case is worth? Matter of fact, I hear that all the time, and I just laugh on these lawyer advertisements where they say, give me a call and I'll tell you how much your case is worth. Well, I would never tell you on a first call how much your case is worth, because there's no way that I would know unless you can supply me with your biography, a complete biography, meaning I know who you are completely, and you supply me with all your medical bills, medical records, and I know everything there is that I can possibly know about what happened to you before, during, and after the accident.
Right.
Can't do that in a phone call, a single phone call. It's just not possible. Yeah. But there are some factors. I think the biggest factor probably is quality of medical care.
Oh, most definitely. The better the medical care, and the better that is recorded in the medical records, the stronger the evidence that you can show to a jury or the adjuster to make them understand that. So when we're talking with our clients, we advise them, it's very important to be detailed with your doctor about all of your complaints. I see it over and over where somebody has a very bad injury to, let's say, a broken arm, and it's causing them a lot of trouble, but they also have some other injuries that are less significant, and all the focus goes to the broken arm, but not to what these other injuries are. And sometimes once the arm starts healing, pain gets better, they start noticing other issues with other parts of their bodies. And part of that can be, well, when the arm's healing, probably not doing a lot of physical work or anything like that, but you get through some more time of healing and you say, well, I've got these other injuries that are actually pretty significant. And it's a matter of telling your doctor about all of the injuries so they can treat them, and it gets documented.
Mental anguish is a recoverable element. How do you quantify it or qualify it to come up with a settlement?
Yeah. On a more significant type of an injury, it may be that the person gets some type of counseling that helps go through and figure out how that injury is affecting them and how to work through it. So getting that kind of medical care or psychiatric care, psychology care would be one way to document those type of damages. We also find it's very important to talk to the family of an injured party and close friends, because they're going to see things that maybe the injured party's not really comfortable telling you about. Sometimes they don't even recognize that that's an injury that they've got. So it's a matter of doing some research, digging in, and finding out from the client and from people close to them, what things are affecting them.
So you're talking about probably one of the most important witnesses. I know we have a trial coming up where we talk a lot about before and after witnesses.
Sure.
And it seems to me that in this trial that we have coming up, before and after witnesses are going to play a pivotal role in analyzing how this injury, how this accident affected a person's both physical and emotional well-being. How does someone, how is that prepared, or how is that accomplished?
Yeah. And again, it's not in all cases, but in the cases with a more serious injury, we find going out to the house of your client and getting to know what goes on in their day to day and talking with your client, figuring out who are close friends that have seen them before the crash and after, and can testify about the changes. Well, Bob can't go out and mow his grass anymore because whenever he does, he's down for the next couple of days with excruciating pain. So you talk to these witnesses and start learning what they see and how that can be presented to either an adjuster or the jury to explain the extent of the injury.
Another category that is that requires professional help often is lost wages. When someone loses a job or can't do a particular occupation. Many times I know we have hired a vocational specialist and or economist.
Yes.
How do we arrive at a lost wage, like a future lost wage analysis for someone?
So what we do in those type of situations is you contact a generally it's a doctor, sometimes a nurse practitioner who has a specialty in this type of work. And they will actually have an appointment with your client and very, very detailed interview to talk about all the different ways that the injury is affecting the person. And then how does that transfer to the job? Yeah, we would have them look at the work history of the injured party, and then they can take that information and look at other occupations that are similar that the person's qualified for. And if it's a job that's not going to pay as much, then they can do calculations on what the loss is between the job they had before a crash and then the job that they're able to do, but may not be such a high paying job. And that vocational specialist can set forth what that loss is per year and what it amounts to over the life of the person, the work life.
All right. I wrote down another form of economic loss is economic loss of services. There's value there when you lose the help from your spouse. For example, if your wife did all of the laundry, if your wife did certain types of chores, and there's an economic loss to that when she can no longer do that. How do we get those included in the damages in a personal injury case?
Sure. Well, one of the first ways is with the injured party's own insurance. There's a PIP benefit that pays for that type of a damage. And so we tell people about this type of damage and see if it fits. So this is your essential services or substitute services damages. So we will have the injured party give a form to whoever's giving them the assistance, whether that be the neighbor that's cutting the lawn or somebody that's coming into the house to do cooking and cleaning. They fill that out and put in the rough value of what their time was. And that can be submitted to your own insurance for reimbursement. But doing that also starts the documentation that we can then present to a jury about all the things that the client needed assistance with.
So I take it that permanent restrictions and limitations are absolutely essential to be looked at, evaluated, and analyzed for both lost wages and future economic loss.
Most definitely.
Okay. And with some doctors are real good about that. Some doctors are not.
Right.
How does a person go about getting an appropriate analysis from a doctor for that?
Well, you can, hopefully when you're talking with your doctor, you're being very detailed about things you can and cannot do. And so if that gets into the medical records, you can then provide that to your own insurance company for proof that you need assistance with things. And that same evidence would then be used at a jury trial or submission to an adjuster to document and prove those type of damages.
All right. I wrote down as the next line of damages, scar or physical disfigurement. Many people in accidents suffer either a burn type scar or a cut that had to be stitched on their head. Scarring or disfigurement really is kind of a sexist world, isn't it? For
Yes.
example, a scar across a older man across his face is not worth anywhere near as much as a scar of an 18-year-old girl.
It definitely can have a different value.
Why is it valued differently?
Well, a jury is going to have to come to that ultimate conclusion of what that's worth. And just because of our culture, we kind of are not as troubled when an older male gets a scar. It's not as big of a deal to a lot of men, but it can be to a younger person or a female. It depends on where the scar is also, of course. But yeah, you do have to deal with adjusters minimizing those type of injuries on certain cases.
Future medical is another category that will often come into play in personal injury cases where there have been serious injuries and all of the medical care cannot be taken care of before you have to file suit or your time limitation runs. How does a person go about getting an analysis of the value of their future medical care, especially if it's an 18-year-old who has multiple injuries? Scarring, but also perhaps injuries to their spinal column, to a knee, etc. They have been told by the doctor that they may need surgery, but they're not doing surgery.
Right.
How is that all taken into consideration and
Sure.
calculated?
Yeah, it can be difficult. Sometimes it can be easy. If your treating doctor is willing, you can get them to set forth what the prognosis is for the future, what medical care might be needed. But honestly, doctors want to treat. They don't really want to get involved with legal matters as much. So yes, you can get a simple report from a doctor, but in a more significant case, what we're really finding is much better is to have an independent medical examination done by a doctor who's competent for the different areas of the body that were injured, and let that doctor who is going to have an opportunity to review all the medical records and do an examination of your client and meet your client. Let that doctor kind of be the overview of the injuries rather than having to go to each specific doctor that you've been treated by. Your treating doctors will appreciate that, because that setting forth the basis for damages is not really going to be on their shoulders. Their shoulders are going to carry this is what the injury is. This is how it has affected this person. This is what we had to do. Leave it to your expert IME doctor to put it all together, make a report, and they can put in there what they find are the foreseeable future care needs and document all those type of different things that come into play.
But once you have that future care need, don't you need another type of specialist or expert to evaluate the actual dollar amount?
Sure. A life care planner can come into play at that point.
What's a life care planner?
So a life care planner is another type of a doctor, not always a doctor, but another type of expert that can be involved in a case that's going to take all of this information, put it into a report form, setting forth all the damages that this person's going to need in the future, a care plan for their future. And that is a great document that you can then present and before the jury with testimony and the report, or to the adjuster to help them understand how significant the injury is.
Now, we're talking about all these different types of damages, but I want to talk now about a particular case that had an impact on damages on many of my cases about halfway through my career. the Kansas Supreme Court decided the case of Martinez, and I can't remember the entire site.
Right.
It's not really important. We just call it Martinez damages. And what they decided many eons ago, about 15 years, I think it was to recalculate the way we consider medical billings in a personal injury case. It used to be that someone would go to the emergency room and have a particular bill, $10,000 bill. That bill, if it's in writing from the emergency room, could be used in the case as evidence of the value of damages the claimant or plaintiff has sustained in the accident. The Supreme Court said, well, now, wait a minute. Many of those bills are written off or written down by the healthcare provider, and so there's a duplicative recovery. Well, when they make that recovery, the Supreme Court is wrong on that. I believe it's been proven that they're wrong, but that is the law, is that in Martinez case provides that the insurance company can show to the jury basically the write-offs, the reductions in the bill. And for many years, we were left with a system where a $10,000 bill became a $250 bill, literally. And the insurance company then didn't put much stock in that bill, and the juries had a tendency not to either. I think that trend has kind of shifted. We still have the Martinez case as the law of the land, but now many lawyers, including our firm, will often just present the entire bill and tell the jury that this is what the bill was written down, and tell the jury that they can award whatever they feel is appropriate. But Martinez damages, Martinez medical bills is what I call it, is a real bone of contention still in affecting the value of the personal injury case.
Yes. What we do find is that adjusters specifically, but also jurors in some respects, if a medical bill's been written down, the adjuster is going to say, well, the value of that injury is just whatever was paid. So you've got $1,000 bill that was written down to just $250. Well, they're saying this is an insignificant injury. Look how little the medical expense was. And so they want to play on that low amount to hopefully keep a jury from saying, well, this isn't a very significant injury. So when we're faced with that, we're pretty upfront. Here's what was billed. And after all the write-offs, this was the amount that was finally owed on that bill. And let the jury decide. Again, tell them about those reductions. They don't get to know why there were reductions. We can't mention health insurance to the jury, but they do get it figured out. But we try to explain it to them in a way that they understand that there's some negotiation there by these powerful insurance companies, and it doesn't necessarily mean that a bill that's reduced down to $250 means it's an insignificant type of an injury.
What's ridiculous about the whole process is we really don't know what the value is of medical bills from case to case, because if you are uninsured, they will hit you with a $10,000 bill, the hospital might, and they may pursue you in collection.
Sure.
For the full value of the bill. Same scenario, different person. They have insurance coverage. When they accept the insurance coverage, maybe a Medicare insurance or just a private insurance, they may accept $1,000 of that $10,000, and the rest of it is written off. They accept the balance of $1,000, and the rest they're willing to write off. And so you say, well, no, wait a minute, the same procedure, same exact thing was done. Is it worth $1,000 or is it worth $10,000?
Right.
Which is it, Mark?
that's the big question.
And so that's what we struggle with. And with good attorneys making presentations, making juries understand this, I think that people have begun to realize that, even though it was written off, for example, there's still more value than $0 on that medical bill.
Yes.
So if you get stuck in the situation where the insurance company is saying that your case is not worth that much just because of the Martinez case, you need to understand that you're not limited to just showing Martinez dollars. You can show the entire bill to the jury. The last area touched briefly here is loss of consortium. Loss of consortium is defined in Kansas as loss of familial affection.
Right.
And that includes your inability to not only love, cherish, help your wife, but also your kids, your family. And it's an important thing because in many times it's not duplicated in any other recovery. So making sure you define the loss of consortium and make a claim for it is very important in a family situation.
Definitely.
All right. Those are many of the damages that you can recover in a personal injury, automobile accident case, or truck accident case. Be sure you talk to an attorney and be sure you understand that damages are recoverable, and a good attorney will know how to put that case together. This is Lawyer on the Line podcast, and we will see you next time.
Please be sure to like, subscribe, and comment. Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.